All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, welcome back live in the studio this afternoon. As you remember, last week we were from Shooting the X in Carlisle, so if you get a chance, stop over there and see their new 3D archery range. They still have my bow, which they're working on, so they better get it back to me pretty soon, because otherwise I'm not going to be able to do anything this hunting season without it. Jack, you have a question?
Yes, I do. My father passed away, and my sister was the executor, and she didn't follow my father's will. Well, her attorney sent me a letter about sign off for probate. They didn't want to go through probate.
Mm-hmm.
I didn't sign it. So then they sent me one, how much money I'm going to get. And I don't really care about the money. They want me to sign. So I didn't sign that. Now they sent me a letter that says if I don't sign this, the probate costs, all legal costs and everything are going to be charged to me. Can they do that?
I don't think so, but I would need to take a look at what's going on and why.
Well, my father left $1,500 to take care of his dog and cat.
Mm-hmm.
And my father had dementia. She changed the will and everything while he's in the hospital.
Gotcha.
And she put her daughters on the will and everything.
Well, you may be able to contest the whole thing then.
I heard that's awful expensive and nothing really happened. It's kind of hard to prove that dementia now since he's dead.
Right.
And I don't really care about the money or anything. You know, I was just glad to have a father. But I just wanted to know about whether they could bill that to me. I read some stuff I took a class once where the money comes out of the estate.
Yeah, and let me put it this way. General rule, you're not entitled, you don't have to sign off on a family agreement. You're entitled to have it pushed through probate and, a final accounting done formally, and that's not anything you're required to do, so I don't think they can pass the cost on to you.
Can I testify, or will the judge ask me why? Will they call me in? Maybe.
I'd have to see exactly what they're trying to do and why. I just don't feel like I know enough without looking at the paperwork. So,
okay, maybe. Where are you at in Carlisle?
155 South Hanover Street.
Okay, I'll just stop over sometime.
All right, do that. All right, my friend. By the way, probably Steve Snyder, who's going to join us here on the air in a little bit, would be a guy who could look at it, as could a couple of the other guys in the office. So if I'm not there, one of the other lawyers may be able to help you.
Yeah, how long you open in the evening or whatever?
Well, we're generally there from about 8:15 in the morning until about 5 o'clock at night.
Okay.
And then we're in there a lot of Sunday afternoons as well.
Okay.
All right, my friend.
All right, thank you.
Thank you. 540-0580. Steve.
Yes, hi, Carl. How are you today?
Good. I see you called in. What's going on?
Well, I appreciated the gentleman that said, Carl, how do you know all this stuff? I often think that myself, having worked with you for some time now.
Well, I have flashcards.
Mm-hmm.
Carrie, you're on with Carl and Steve.
Hi. My question also concerns identity fraud. An individual who I had a previous relationship with has recently started using my parents' address, their home and home-based business's address, as an address on a bank account he's got, where he's overdrawn the checking account by like $500 and some.
Mm-hmm.
I got a statement. It was a notice of charge-off from the bank to my parents' address, and I'm just wondering, the fact that he's using their address, do they have to do anything to protect themselves?
Well, I mean, an address doesn't really care. You know, if you live, I guess if the house is haunted, the address matters.
Right.
But if you live there and I live there and then somebody else lives there and a fifth guy lives there and then we all go our own way and then somebody else moves in, there may be bill collectors looking for some of us at that same house.
Yeah, no, I don't live there and he's never lived there.
Right.
I mean, it's obviously some sort of ploy for him to somehow associate himself with that address.
And the short answer is they're not going to give him loans or anything based on the address because they're going to want to see actual ownership before they'd allow him to encumber it, and he wouldn't be legally able to encumber the property. So I don't know what his plan is exactly. It's not good form, and I guess they could do a cease and desist and say, stop using our address and that this is fraud.
Right. And that was my other question, is the fact that he used their address to open this checking account enough to have him charged with some sort of identity fraud by itself?
I don't think he's usurped anybody's identity yet, arguably.
Well, no, yeah.
But I don't know. I mean, it just seems nefarious.
Yeah, very nefarious.
Steve.
He got arrested one time and tried to tell the police that he actually was my son and used my son's social security number. So, I mean, he's got a history of doing really sketchy things.
Oh, yeah.
So I was just concerned and wondering if I could have him charged with something.
Yeah, I would talk with the police and see what they think.
Okay.
I mean, it can't hurt.
Sounds like a plan.
All right. Take care.
Thank you.
Kelly, you're on with Carl and Steve. Kelly.
Yes, hi.
How are you?
Good, how are you?
Not too bad.
I have a question. My husband and I own a lawn care company,
Uh-huh.
and we filed with the district justice, got a judgment for us, and then actually went and had the sheriff try to serve a levy.
Mm-hmm.
And now it's to the point where he just claimed Chapter 7 bankruptcy.
Okay.
Is there anything we can do? I mean, we have a signed contract with his signature saying he would make payments. We were willing to give him basically a 2-year interest-free loan, and he only paid, a couple $100, outstanding balance of like $4,800.
Right. But he has actually gone bankrupt now?
He did file for it, so we're not sure if it's actually,
Right.
I mean, it may not be, he may not be able to, but we're just, to go to the meeting of the creditors, I guess, and see
what happens.
He actually has. But I know he does a business. We're both in the same field, health, fitness type of thing.
Mm-hmm.
I know he does a large cash business. So I don't know. I read that I could get like 2-year tax returns. Could I get 2 years like request 2 years bank statements and try to show how?
I think if you go to the creditors meeting, you can get some of that information. Yeah, they're going to have that. Okay. But I guess the big answer here is how much money do you want to spend to try? If he actually goes bankrupt,
right?
He's probably not going to be committing bankruptcy fraud. We hope. If he does, I would assume you could undo the bankruptcy if it's later determined he was fraudulent. But that's what the court's going to do. They're going to try to make sure it isn't fraud. And if he does go bankrupt, then you'll have no money to collect. So I just try to figure out how much money you want to spend trying to collect money from him. How much does he owe you total?
Like $4,800.
Yeah. So it might be worth some diligence to spend a few $100 to see what's really going on.
Right. So first thing, just go to the bankruptcy clerk and see what he did file.
Yeah.
And then if I think there's something else, hire an attorney to try to investigate that more.
Exactly.
Okay.
I mean, but my sneaking suspicion is if he's in a Chapter 7 bankruptcy, to qualify for a 7 and not a 13, he's going to have to be a real deadbeat at this point. So
yeah, that's what we're thinking. Doesn't really help us, but I know that there's a lot of things, and he just lied from the beginning, so I know he's probably hiding stuff. I just don't know if it's enough to get it so he doesn't qualify.
Steve, what do you think of Kelly's problem there?
Well, I was just working on a mechanics lien for a contractor that did some work, actually asphalt paving. Unfortunately, it doesn't cover lawn care, but I was just thinking, there's a lot of contractors and subcontractors out there that run into this type of a situation where they do work for somebody, and the problem with contractors is if you put a roof on a guy's house, as an example, and he doesn't pay you, you can't go out and repossess the roof. And so Pennsylvania has a very far-reaching mechanics lien law, and so contractors and subcontractors that do work for somebody and don't get paid are able to put a lien on that property, and then they are able to collect any time that person would try to sell that property. And I think the thing that's important to note is that the time limits on those things are very, very specific. And so if you're a contractor or a subcontractor that does work to a residential or commercial property and don't get paid, it's important that you get in touch with an attorney quickly and make sure that you're protected in that case. But unfortunately, that doesn't fall under the lawn care example doesn't fall under the mechanics lien. And as you mentioned, a lot of times you can spend a lot of money going after small debts like this, and sometimes it's not worth the time and the headache involved.
And, of course, a terrible thing is when we say small debts because, personally I think $4,000 is a lot of money. Mm-hmm. It's just that from a business standpoint and the cost to pursue it, it doesn't rise. But
right. I just know another couple that, they went bankrupt, and 2 years later they took a 2-week vacation to Ireland. And
that's the beauty of bankruptcy in America.
It's sick. We have the opportunity to go the other way instead of opportunity. It's an opportunity to be lazy.
It's weird because our bankruptcy system is frustrating in some ways, but a lot of people believe that one of the reasons our economy's always done so well is we've had a better bankruptcy system than most of the world, where we literally don't shackle you to your debts for life if you don't want to be, and allow you to restart. And quite frankly, you'll find that a lot of entrepreneurs and business people have been through multiple bankruptcies. I believe the guy that founded Curves actually went through 3 bankrupt gym businesses before he came up with Curves. And he wouldn't have been able.
I think it's bankrupt now.
Well, hopefully he got kept a little money that time.
Right.
All right, Kelly, I got to go to break.
All right, thanks so much.
540-0580. See you after the break. Hey, welcome back. 540-0580. Joined here with Steve Snyder from my office, who is tagging along for the ride here, so to speak. Pat, you're on the air with Carl and Steve.
Hello.
Yeah, what's going on, Pat?
Hey, I had a question for you. My best friend is about ready to go through a divorce right now, and his wife was she ended up messing around on him or whatever, and she moved out about 4 months ago. She took all of her belongings with her, and they have a child together, and last week she had asked if she could come back to the house and get some of her daughter's clothing. Mm-hmm. Well, she ended up taking several of his guns and a few high-dollar computer, some high-dollar computer equipment. And, he allowed her to come back into the house. She moved out and she has her own house now, but I was wondering, they're not divorced yet and he hasn't filed yet. Does she have the right to take those things?
Well, they're marital property, right? Supposedly.
Yeah.
So, I mean, kind of, sort of. You could do a motion or get an order that says, you can't take anything else, or you have to give those items back, and they're all at play in the divorce.
Right.
So, but I guess
at this point, he really doesn't have a leg to stand on.
It's not really theft unless she destroyed him or something,
Well, I'm sure. He had told me that she had overdrawn her bank account, so I'm sure she's probably going to sell the guns that she took and stuff because she doesn't hunt or anything. So
do you know what she's selling?
I'm sorry.
Do you know what she's selling?
I know
that's a joke.
It was a 243 or something. He paid like $900 for. So
I'll give her $700.
I'm sorry.
I'll give her $700. Yeah. That's anyhow. No, but seriously, I mean, he could get an order to restrain her from selling them. But it's that nebulous area of marital property again.
Right.
And I guess he just shouldn't let her back in. That would be the other advice.
Well, does he have? I mean, she is on the deed also. So does he have the right not to let her in?
He can change the locks, and then she can bust him down, and then she can change the locks, and he can bust him down.
Right.
And they go back and forth like that forever, or either one of them can probably get an order from court to just sort of say. But if once one party moves out, most courts will simply say, okay, quiet use of the marital property goes to the party who stayed, not the party who wants to come back in.
Right, and she has had another residence for 4 months, so apparently that's not her residence anymore.
That would be the general gist, but technically it's her property, So if you and I own a house together and we're both on the deed and we're not married, I can still beat down the door. At the end of the day, though, one of us is going to get mad at the other one, and that's why courts will intervene. And in the marital realm, they can intervene under the power of the marital law to give exclusive use of the marital residence to one party or the other.
Right.
That
makes sense.
I've even seen horror stories, though, where one party moves out and then they get to move back in over the other party's objection, and that guy or gal gets kicked out.
Mm-hmm.
But sometimes
his best bet is to go to his lawyer and
get an exclusion. Yep.
Right.
All right, my friend.
Okay, thank you. I appreciate it.
540-0580. Kelly.
Hello?
Hi, Kelly.
Hey, Carl. I have a question. We had bought a house about 5.5 years ago, and the people that lived here before us were here for roughly 30 years. There's an addition on the house that's 19 years old when we moved in, and we bought the house in January, and by that spring we had gotten water back in the family room. Now, we live on a hill. We do have a sloped backyard, but our basement has always remained dry. So we had this flood, and we've had more water. Last August, we put in a new patio, a French drain, a dry well. Thought that would take care of it. It didn't. We put a box drain in. The guy actually did an amazing job, but we really got hammered this time. My question is basically the people that lived here first had filled out the disclosure form and said that they never had water. But I have two neighbors that both said that they had told them.
Oops, sorry about that.
Oh, no problem. They had told them that they had water in the back room. And I also have a neighbor that said that every time there was a heavy rain, the next day she would see furniture sitting outside.
So it sounds like a misrepresentation and a fraudulent misrepresentation. So you would definitely have recourse. How long ago did you buy the house?
Like 5.5 years ago.
Okay. And you just noticed the problem when?
Well, we had water, the very first year we moved in. Now, it wasn't significant because it didn't rain that much. But over the years now,
right.
This past April and May was really bad. And then this past rain, we pretty much have to quarantine that whole room off at this point. I have 4 little kids and, everything was damaged.
Steve, let me stop you for a second. Steve, does this sound like a statute of limitations problem to you?
Well, that's the problem. Pennsylvania has a very specific law on residential sellers' property disclosure, and it's construed very strictly against the seller. The seller's required to disclose that kind of information. The problem is in Pennsylvania and every state, when you have some kind of a legal claim, you're required to raise that claim within a specific period of time, and it's different for different types of claims. The best thing to have done would have been as soon as you realized you had a problem, that's when your cause of action arises. Now, if you lived in the house for 5 years and you didn't know you had a problem until the 5th year, then you could argue that you didn't know you had legal recourse until that period of time. But I'm concerned the way you preface the story that your statute of limitations may have run on that claim.
And Kelly, here's the problem in Pennsylvania is we're one of the states where it's kind of like what you kind of should have known as well as what you do know. And so I understand you're saying the water wasn't real bad at first. It just seemed like not a big deal, blah, blah, blah. But it's sort of like it reminds me of the Med Mal cases, and the guy says, well, I didn't realize they left a sponge in my belly. It took 5 years. And then during the deposition, he says, yeah, I kept having a pain in my left side, about 6 weeks after the surgery, and it never really went away, and I always wondered what was wrong. The courts will be like, well, that's enough. That should have sent you back to the doctor right then, so we're not going to toll it until when you actually found out about it, but when we think you probably should have started looking at it.
Yeah. Okay, well, I was just curious with the neighbors, stating that they know, because it's one thing if you live here and you really didn't have an issue.
Right.
And, we're not looking to put anybody under the bus. It was just
Hey,
that room was the whole reason we bought the house. And
we did one years ago where the sellers claimed they had no knowledge of the water and the rotting under the kitchen or whatever.
Yeah.
And when we pulled the house apart, I say we, meaning, I was just a lawyer on this thing. I don't give you the wrong impression, but underneath the floorboards was wood, which was date stamped during their tenancy in the house. Yeah. And you're like, so somebody came in here and nailed boards into the floor and into the basement, and you didn't even know it. That's amazing.
No, sure. And that's that was kind of my whole thing, is they really didn't seem to care much. And this is when the market was great. The house was on the market for like 17 days, and we picked it up, and
right.
So
it sounds like you have a statute of limitations problem. I would counsel you that if you're serious about the damage and want to go forward or at least look at it, you do need to sit down with a lawyer and go quickly. I'm thinking that for fraud, the statute of limitations is 2 years and breach of contract is going to be 4, but there might be some other way to make it longer. I don't know.
Okay.
All right?
Well, thank you for your help. I appreciate it.
All right, take care.
Bye-bye. And
Steve, I know that you're my property guy, so you certainly know the answer to that. That's the seller's disclosure is strict.
Mm-hmm.
Very strict in Pennsylvania.
Yep.
But you got to do something about it, and I feel bad for her because I know what happened. It was dry a few years ago.
Yeah. We're seeing a lot of water damages these days.
Well, as I said, I was saying a couple weeks ago that everybody used to write on their seller's disclosure, we haven't had water since Agnes.
Yeah.
Now they're going to write, haven't had water since Agnes or Lee.
Mm-hmm.
George, you're on with Steve and Carl.
Yes, good afternoon. Thank you for taking my call. My question is relative to an adult boomerang child. If he would allow his insurance to lapse on his car, would I in any way be liable because he's living under my roof?
I don't think so. It's his car, right?
Correct.
He doesn't own the house, so you're not really responsible. I mean, I guess if you loaded him drunk in the car and handed him the keys and sent him down the road, you might get drug in somehow, but other than that, I can't imagine.
What's a boomerang child?
One who has left the home and has come back.
Okay.
And how long did the boomerang fly for? A year or three? Or
about 6.
About 6 years? Okay.
Just when you think you have him out of the house.
All right, George, I don't see any great exposure there, but I would kick him in the butt and tell him to be responsible.
Yeah, okay.
All right.
That's just been, in conversation.
Throw him harder next time.
Yeah.
All right.
Okay, thanks.
540-0580, have to go to break. Well, the Florida straw poll, wait and see what happens. I can't believe it. Anyhow, 540-0580. Hi, my name is Rick Perry. I have some of Ronald Reagan's lint in my pocket, and therefore you should vote for me. I mean, we were talking about this earlier. Reagan. He's a great guy, right? But everybody has a reason why they're like Reagan. I mean, it's kind of like, reminds me of the Bible. Everybody's got a verse they want to quote that just applies to the situation. Everybody's got something about Reagan that's like them or why they're like Reagan. And not like Reagan, or however you want to put it. I don't know. It just drives me nutty. 540-0580. And Reagan was a great man. Just want to be clear on that, in case anybody got the wrong message there. Cheryl.
Hello.
How are you?
Oh, I'm good. How are you today?
Good. What's going on?
Okay. I have a rental property, and there was no lease, and there was a rolling delinquency, and I got tired of dealing with it. I had promises every week, I'm going to pay it. And to make a long story real short, they never paid it. And they moved out on the 12th of August without paying any of August rent.
Gotcha.
Okay. What?
You can sue them at the district justice level and get a judgment against them. And because it's landlord-tenant, Steve, correct me if I'm wrong, because it's landlord-tenant, we can get a garnishment on wages, right?
Well, yeah, I actually have a client that I'm working on that right now with, and the law is not real clear on garnishment of wages. The legislature some years back actually amended the law. Pennsylvania is one of the few states that allows garnishment of wages for back rents not paid, and I've actually just been reviewing the law to determine how that's done. One of the problems we have is sometimes when these people move out, it's hard to find them, and it's hard to find out where they're employed and things like that.
I know where they work, and I know where they live.
See, okay.
There you go. That's the easiest thing right there. So if you have a judgment, and that's what you need first, you need a judgment. So you have to go to the district justice, and it's just like filing a lawsuit. And once you get the suit filed, they'll get notified, and if they don't show up for the suit, you'll get a judgment. If they do, then you can still prove that they haven't paid that back rent. And once you have that judgment, then we can file a motion for garnishment or wages.
Okay, now here's another part of this equation. There were two girls living in the place, and the one girl paid her rent religiously. The other one didn't. But I maintain that it's a delinquency on the rent, not on the person.
Yeah, it's joint and several, I would believe.
Right. So if I would file a lawsuit with the district justice, I would file it on both of them.
Sure.
For the rental of the property. Mm-hmm. Now, I'm entitled to a 30-day notice if you're moving, right?
Well, you're entitled to 30 days notice to quit, so you'd owe them for that last month that they didn't give notice to quit on as well, yeah.
Right, and they stayed there half of the month.
Yeah, so you can lapse that over as well.
Okay, now, how do I get direction on filing this with the district justice?
Cheryl, you got two options. I mean, one is go down to the district justice and they'll walk you through some of the procedural stuff themselves. The other is to just hire a lawyer in the first instance and have them walk you through it.
Okay, but when I did go to the district justice and pick up the papers, they said they couldn't advise me on anything.
Yeah, see, every district judge's office is a little different. Some will actually just tell you what kind of like write your story here. So short answer is I would advise you at this point then if that's the deal, you might want to maybe even talk to Steve or somebody about what to do off the air. Okay, and how do I get a hold of Steve off the air? Our office number is 241-6070. 241-6070. Yep. And his name is Steve? Snyder, Snyder. Okay, and during your regular office hours? Yeah, we're usually there from about 8:15 to 5, and Steve's usually there working hard away other hours too, although the phones aren't always lighting up at that point. Okay, I think I need an attorney to direct me. Yeah, the short answer is if this isn't something you've done before, especially the first time or two for a landlord, and then a lot of times we have a lot of landlords who use us for all their stuff. We have other landlords who only use us when they have a problem. Yeah. Well, the thing is, these were friends, and that's the worst type because you let the rolling debt go because they were friends. That's what happened. Right. And I've presented several times. I've presented a matrix of what months were missed, how much was missed, and so forth. And they kept saying, "Well, you have to show me. You have to show me." And I delivered it like 3-4 times, and I really got fed up, and I said, "You know what? I'm tired of this, and I have a notion just to sell the place." Should probably just wrap it around a brick and deliver it to their new house. Yeah. Okay. All right, Cheryl. Thank you so much. Right. I will be calling you, Steve. Thank you, my dear. Okay. I appreciate it. Helping you. Thank you. All right, take care. You too, dear. Thank you. 540-0580. Obviously, she's not supposed to throw a brick through anybody's window, if you think I was not kidding. Ron, you're on the air.
Hi, Carl. How are you? Good.
What's going on?
Good. Reagan was a great man, but I'm looking for a candidate who is not Reagan, who is themselves.
Well, I just go nutty because it's everybody wants to wrap themselves in his mantle.
Right. That's just, I want somebody who is going to build on their own self. Okay, who they are. To thine own self be true. That's what I'm interested in. Anyway, that's neither here nor there. I bought a house here about 3 years ago. When I bought it, it's got a basement. And, of course, on the disclosure statement, they said, they do get, a little trickle of water here and there after a heavy rain, which is true. That's not a problem. However, my question is this. With this past rain event that we had, primarily Lee, I had about 2 feet of water in my basement. It was clean groundwater. I mean, it was crystal clear. You could see through. It was just like well water.
It's coming up.
Yeah, it just came up from the ground. And like I said, there was about 2 feet in there. Now, all my appliances survived. Everything I have is basically an antique. I had 2 dehumidifiers that were completely submerged. They both still work. My washer to dryer, they still work. My freezer still works. Mm-hmm. Everything still works. The heat pump down there still works. But a buddy of mine that I work with said that because it was a flood event under a disaster-declared county, he said I should contact FEMA. Okay. And file a report on it, in case something does fail prematurely on down the road. Now, do I have any recourse there? I don't have flood insurance. I didn't reckon I needed it up here on the hill.
Yeah, and I don't know the answer to that. Really don't. I guess, listen, this is how I'd answer this question. Well, go talk to FEMA because they'll tell you if they can help you or not or if it even matters. Mm-hmm. We'll start with that default position. And
I wasn't sure if it was worth even trying to get a hold of a government agency.
Well, yeah, and that's the answer, and I don't know the answer to that. So, again, my only way to handle that problem would be to contact FEMA, right?
Okay, would it be FEMA or PEMA, or does it matter?
I think when you talk to one, you talk to the other for all intensive purposes. I just start with the local PEMA guy and let him go direct you from there.
Okay, yeah, I've never dealt with anything like this, so that's why I thought, well, maybe you would know.
Yeah, and these are the ways, just to give you like my logic of how I approach a problem like this. It's, okay, I don't know the answer, But I guess the easiest way is just go right to the horse and say, hey, what's in your mouth there? And when he tells you what it is, then you know. Otherwise, you spend a lot of time trying to figure it out. But it doesn't also sound like you're looking for immediate benefit either. So,
No. I wasn't really worried about anything. I was just telling his coworker of mine, about the situation, how fortunate we were that everything still works. He says, "Yeah, well, what's going to happen if it quits a year from now? Are you entitled to something?" I said, "Well, I don't like being entitled to anything from the government."
And here's the next question. I mean, here's my mind. It's like, and how do you prove that, right?
Right.
I guess you got to pay the plumber to come in or pay somebody to come in and go, no, it happened because, fill in the blank. The who's and what's is corroded, and it must have. Did you have water in your basement about a year ago? Oh, okay.
Mm-hmm.
So I doubt it's worth your time, but it can't hurt to just call somebody.
Yeah, well, that's sort of the way I felt too. I thought, well, you're free. I'll ask you.
Right. Well, here I am, and of course I gave you the great answer. Call somebody else.
Typical lawyer.
I know. Well, you're right. I never actually answer the question. I mean, come on. If I start answering questions, they'll fire me.
Yeah, there you go. All right. Hey, you be safe.
All right. Take care, brother. Oops. 540-0580. See you after the break. Hey, welcome back. 540-0580. We talked about Slinder a little earlier, and I see their executives have taken the Fifth Amendment. Remember, you have that right not to testify, or even talk to the police for that matter, and Congress calls them in and says, hey, we need you to talk, and they say, we're taking our Fifth. That's actually a good play, though. What you do in front of Congress is you take your Fifth, and you hope they grant you immunity, and if you get them to grant you immunity under the right circumstances, then you can spill your guts about all the horrible things you did, and the federal prosecutors can't do anything because your congressional grant of immunity screws up their ability to convict you. So sometimes that's the strategy. Okay, Congress, you really want me to testify? I'm going to take the Fifth. Now you give me the right grant of immunity, and then I can tell you all kinds of things without fear of further prosecution. Jeff, you're on with Steve and Carl.
Hi, Carl. Back in February of 2010, my wife and I unfortunately had to file personal bankruptcy. It was a Chapter 7 bankruptcy. It was discharged on June 11 of 2010. Part of that was our house went into that bankruptcy. And we were kind of advised to walk away from the house at that point by both my attorney and by a realtor. And we haven't heard anything from our former mortgage company until just recently that we're getting letters now that it's in claims and we're supposed to meet them in court coming up here pretty quick. But I'm just wondering, are we exposed here? I mean, do we need to be dealing with them at this point, or does the bankruptcy discharge having the mortgage company named in the bankruptcy clear us of that, or what?
So, in your bankruptcy, you probably listed the house as an asset.
Yes.
And you probably put down that you were planning to surrender it back to the bank.
That's correct.
And at this point, the bank has not taken it back or done anything with it.
That's right.
So have they come to you about renegotiating the mortgage at this point?
Well, we had tried to do all of that even before the bankruptcy.
Right.
So we really haven't been in communication
with them at all.
Since then, we have tried since the bankruptcy to let them know, hey, this has been discharged, and we're trying to. We'd like to move on. Plus, the house is sitting there now empty for a year and a half. We not only surrendered it, but we moved out, and so we're concerned about the house falling apart as well. But now, and we haven't heard anything from them, and now all of a sudden we're getting this notice in the mail from a debt collector,
right?
And that we're supposed to get a lawyer and go to court and all this kind of stuff.
Yeah, can I jump in, Carl?
Yeah, Steve, grab it.
Yeah, here's the thing on that. The Consumer Protection and Unfair Debt Collection Practices Act is very, very clear on what debt collectors can do. And as long as you explain to that debt collector that this, number one, that the house was or the debt was discharged in bankruptcy, and number two, that you have an attorney that represented you in the bankruptcy, they have to cease and desist all future contact with you. So the simplest thing to do there is just let them know the name of the attorney that handled your bankruptcy, and that'll discontinue all future contact from them. And if it doesn't, you're entitled to sue them, and you're entitled to get treble damages if they violated the Consumer Debt and Unfair Debt Collection Practices Act. So you can make that go away pretty quickly, assuming that debt was discharged in bankruptcy.
And Steve, the other thing is he did jump off the line, but I think the thing we could do also is probably he needs to do something to get the bank to accept a deed to the property to get out of his name.
Yeah.
I think that would be worthwhile. Oh, Jeff's back here. Good. Jeff, you're back?
Yeah.
Did you hear what Steve was saying on your radio or no?
I called the tail end of it that it's basically kind of illegal for them to be coming at us the way they are.
But it also seemed...
Let them know you're represented by an attorney and give them the name of the attorney that handled your bankruptcy, or if you need a new attorney, we can certainly help you or anyone else can. But as soon as they have been informed that that you're represented by legal counsel, they have to stop contacting you immediately.
Okay.
The other thing, Jeff, is it just seems like we should clean up the deed issue and either get the bank to take a deed, or what I would usually do is probably put you in touch. If you listen to the ads during the show, Coldwell Banker Select Professionals advertises during our show, and they do a lot of short sales.
Yeah.
They could certainly try to help you with it as well to unload it with the bank. So just some ideas.
We had tried to communicate with the mortgage company a couple different times to let them know that, hey, this bankruptcy is discharged, and they even sent a letter on our behalf to try to get I think it's called a deed in lieu.
Yes.
Yeah.
And we would just continue to hear nothing from the mortgage company.
So.
I'll tell you, we get contacted by so many people that are in trouble with their mortgages, and it's very, very difficult to deal with these mortgage companies. And the reason for that is there are so many people that are in arrears on their mortgages and in danger of foreclosure that it takes banks sometimes years. I know people that have lived in their homes for over a year having not paid their mortgage because of financial difficulties, and the mortgage companies just don't even have the time to get to them. They have so many mortgages, so it's hard to work with these mortgage companies because they're so large and they have so many mortgagees that are in financial trouble. It's a tough time right now.
Right. Yeah, I understand.
All right, Jeff, I hope we helped you out there.
Yes, you did. Thanks a lot.
All right, take care, brother.
All right, bye-bye.
Carl Rominger here answering your legal questions. I'm joined by Steve Snyder. And, of course, if you need to get hold of us, you just go to romingerlaw.com. We also just put up a new article on preliminary hearings. So if you ever wondered about a preliminary hearing here in Pennsylvania, if you just go to romingerlaw.com, you can read that as well. Or if you just need to get our phone numbers. If you can hear our broadcast, we're probably able to help you. Bob, you're on the air.
Yes, in 2007, I lost the case and a judgment come against me. And I paid their judgment before the due date of the court due date to the court. And after that, I was on vacation, and that it was in a small court case, so it's less than $1,000. Okay. So after I come back from the vacation, I see the email that the guy who did that thing, he sent me the email that if you don't pay to me, I will delinquent register you on that thing. So I already paid that. I don't want to talk with that guy because he was such a idiot.
Right.
So I ignored that things, and a month later I got the notice from the court that you didn't pay your due, your judgment.
Okay. But you did pay it.
Yeah, which I did pay to the court before the due date.
Right.
But he registered next day. It was due by the last day. It was Friday or something like that, or Sunday. And he registered on Monday. Very next day, he registered that thing.
Gotcha. So what needs to be done at this point?
That's my question is, it's damaged my credit because 2 years ago when I tried to buy the house, the bank said, no, you have this judgment against you. I told them that, hey, I already paid that thing.
Has he not filed a satisfaction piece?
Who?
The person you paid?
You mean he?
Yeah, somebody has to file a satisfaction on the judgment, right?
Yeah, but he didn't file that thing. It still was on after 2 years.
Yeah. You may be entitled to sue him for not satisfying the judgment upon demand. So what you want to do is show that you want to make demand to him to satisfy the judgment, and that should get it closed out. It's still going to show on your credit report, though.
Yeah, but I can sue him for that.
Yeah, if after demand he doesn't, in other words, you have to basically say, hey, satisfy my judgment, I paid you, and you give him a written demand. If he doesn't, and the longer it takes him to do it after you've given him appropriate demand, which you may have already done, the greater your damages. In fact, it allows for regouging of the money back.
Uh-huh. Okay.
All right.
So I can file the suit again.
Yes. All right, guys, we're out of time here. Hey, Steve, thanks for joining me.
Thanks, Carl.
It's been Carl Rominger here, been answering your legal questions. I'll be back next Saturday, here every Saturday from 1 to 3. If you know somebody has a legal problem, send them to RomingerLaw.com to get in touch with us during the week, or tell them about the radio show so they can just call in and they get a quick question answered for free. And, of course, everything we tell you is based on what little information we have. So the true facts need to be known before we can render an actual opinion in your case.